Hi, this is David Comfort from Democracy Action Network. Here's what's actually wild. For the first 4 years of Chief Justice John Marshall's tenure, we're talking about one of the most foundational periods in American legal history. The Supreme Court issued exactly one single-sentence concurrence and 0 dissents. 0. Until 1928, about 70% of all cases had no dissenting opinions at all. This is honestly crazy, but we've gone from a court where disagreement was almost unthinkable to one where 3 liberal justices are essentially screaming in legal language that the game itself has changed. Ever notice how Elena Kagan used to barely dissent? After Gorsuch joined in 2017, she wrote 30 dissents in just 5 years. That's not normal judicial disagreement. That's someone watching the rules crumble in real time. Her language shifted from respect but deep sadness to calling out the majority's power grab and accusing them of writing their own set of rules. What if I told you that Sotomayor is now opening death penalty dissents not with legal precedents, but with a list of names, the 13 men executed without orderly process? She's literally saying, "This is not justice," in plain English. That's not how Supreme Court justices traditionally write. And Ketanji Brown Jackson? She's doing something even more radical. In her affirmative action dissent, she created 2 fictional college applicants, John and James from North Carolina, and walked through exactly how centuries of racism would affect their lives differently. She's not just arguing law, she's teaching American history. But here's the puzzle that gives me hope. These dissents aren't really trying to change conservative minds anymore. They're doing something bigger. They're preserving what legal reasoning looks like for when we need it again. Think about it historically. Justice Benjamin Curtis wrote a powerful dissent in Dred Scott, insisting that Black Americans were, in every sense, part of the people of the United States. Nobody listened then, but those words mattered later. Oliver Wendell Holmes was called the Great Dissenter, and less than 10% of his dissents became law, but they shaped how we think about legal reasoning. The deeper pattern here is fascinating. When institutions break down, someone has to keep the institutional memory alive. That's what's happening. These justices are essentially creating a legal time capsule, preserving what fidelity to facts and reason-giving look like. Jackson even referenced dual state theory in a footnote, drawing parallels between Trump's approach and 1930s Germany. That's not casual historical name-dropping. That's someone who understands that legal systems don't exist in isolation from political contexts. The question isn't whether these dissents will immediately change anything. It's whether they're successfully documenting what constitutional reasoning looks like for the next generation of lawyers and judges who will eventually rebuild these institutions. History suggests they will. The arc is long, but it bends toward justice, especially when people are brave enough to keep pointing toward true north, even when everyone else has lost the compass. Please like this video and subscribe to our channel. It would help out a lot. Peace.